Okay, I was talking to you about different ways to get your case tossed out to get exonerated. I was talking to you about a quick and speedy trial, and I told you before, if you don't assert your right to a quick and speedy trial, you won't get it. You're guaranteed a quick and speedy trial in the Sixth Amendment of the U.S. Constitution. But if you don't ask for it, you won't get it, and your lawyer is more than likely not going to bring it up. That happens to everybody. Okay, but let me show you this. Okay, in January 2022, Brandon and Gregory Case were charged with attempted first-degree murder for shooting at a black FedEx driver to Montario Gibson. The charges were dismissed on January 2025 due to intentional discovery violations by the lead investigator. What happened in January 2022? Gibson was delivering packages in a van when he was shot at by Brandon and Gregory Case. Gibson was not injured. The cases were charged with attempted first-degree murder, conspiracy, and shooting into a vehicle. The case went to trial in August of 2023. But was a mistrial was declared after lead investigator Vincent Fernando withheld evidence. The defense argued the cases were denied due process and a speedy trial. Judge David Armstrong dismissed the charges, stating that discovery violations were intentional and violated the rules of criminal procedure. What happened after the charges? Gibson was fired from his FedEx job, then he was in therapy. Gibson's attorney said that he would hold FedEx accountable in court for intentional infliction of emotion. Okay, let's go over here. Sorry. Okay, a case dropped because of failure to give a quick and speedy trial means that a criminal case was dismissed by a court because the prosecution took too long to bring the defendant to trial, violating their constitutional right to a speedy trial, often stemming from excessive delays in the legal process. Key points about a speedy trial dismissal. Constitutional rights. The right to a speedy trial is guaranteed in the Sixth Amendment of the U.S. Constitution. Factors considered. When deciding if a speedy trial violation occurred, courts look at the length of the delay, the reasons for the delay, when a defendant asserted their right to a speedy trial. When a defendant asserted their right to a speedy trial, your lawyer's not going to do it. And they're not going to ask you if you want one. The judge ain't going to ask you if you want one, and the state's attorney or the opposing party is definitely not going to ask you if you want a quick and speedy trial. So you must do it yourself, even though you're guaranteed you won't get it. The reasons for the delay, whether the defendant asserted their right to a speedy trial and any other prejudice suffered from the defendant due to the delay. Defendant's action to raise a speedy trial claim, the defendant usually needs to file a motion to dismiss the charges based on the delay. Example scenarios where a case might be dropped due to a speedy trial violations: excessive court backlogs. If a court system is significantly overloaded, leading to long days in bringing a case to trial. Prosecution delays. The prosecutor repeatedly postpones trial dates without good reason. They rarely have good reason, and expediting litigation is mandatory in the rules of professional conduct. It would be diligent to expedite litigation. It would show competence, which it doesn't. But let me just say this, it seems somewhat like a setup. They intentionally did that to have that case dismissed. Failure to properly manage the case. If the prosecution fails to diligently move the case forward, causing unnecessary delays. Like I said, diligence is a law in a court of law. Competence is a law in a court of law. Reporting misconduct is a law in a court of law. Those are all laws in the rules of professional conduct. So any violation of those rules is a violation of your right to Sixth Amendment, not just to a quick and speedy trial, but effective assistance of counsel. And effective assistance of counsel is in the rules of professional conduct. And the rules of professional conduct, as well as the Code of Judicial Conduct, are legal obligations of all lawyers and judges, not just inside the court, but outside it as well. Okay, so there's a lot of things you could read up about this. Sixth Amendment right to a speedy trial. If you don't get a speedy trial, you can just demand, hey, judge, you got to drop it. You denied me my right to due process because you denied my right to a speedy trial. It wasn't a fair trial because I was denied a fair trial, yet alone my attorney didn't mention it, so that leaves him as ineffective assistance of counsel. His failure to bring up, even mention to me, a quick and speedy trial is ineffective assistance of counsel. In effect, not only ineffective, defective, and destructive assistance of counsel. Not only did he defy the oath of office, he defied the oath of public service. And when he did that, he decimated and desecrated and eventually defecated on the U.S. Constitution, of which he took an oath to, as well as every judge and every lawyer takes an oath to. You must abide by, enforce, and report any violations of the rules of professional conduct and the code of judicial conduct. That is mandatory for every lawyer and judge. Okay? So there you go. Quick and speedy trial. You can actually get out of prison on that using the ineffective assistance of counsel. Nobody ever told you about it. Remember, it's required that you give informed consent before a case can proceed. In order to give that informed consent, you need reasonable information and make an informed decision, and that would start with knowing that you have a right to a quick and speedy trial, and that nobody's going to bring it up. If nobody brings it up, you're not going to get it, which is totally ridiculous. It's totally ridiculous. Just like effective assistance of counsel. You're not going to get effective assistance of counsel unless you demand it, and you got to take those laws with you, the rules of professional conduct, the code of judicial conduct. Walk into that court and tell the judge you want to review those so everybody plays by the book. Everything's done by the book, word for word, to the letter. Don't forget the letter of the law. The letter of the law is a mandate in interpreting laws. It requires whatever is written to be done, word for word, to the letter. Okay? But this is one avenue, quick and speedy trial. I've seen people on the news when the pandemic started. Guy was complaining he was waiting for 2 years for a trial. The pandemic started, and he wanted to get the hell out of there. And I couldn't figure out why he was waiting 2 years for a trial when in the state of Illinois it's 90 days for a quick and speedy trial. That was totally ineffective, defective assistance of counsel, destructive assistance of counsel. Why didn't the judge cite him for ineffective assistance of counsel? And the state's attorney for prosecutorial misconduct for not even mentioning the fact that the defendant has a right to a quick and speedy trial, and it's left up to 90 days. And if that case doesn't go to trial within 90 days, it is defunct, thrown out, null, and void. Okay, this is Pop's Legal Reform on Facebook. I'm posting this wherever and anywhere I can. God bless. Have a good night.